The purpose of this pocket handbook is to fully inform the American County Sheriff, deputies, and bailiffs as to their authority, duty, and the law. This handbook is an endeavor to concisely and completely cover the aforesaid in topical style to make it easy for references. We also created a website, www.powerofthecountysheriff.org, to further expand upon the topics within the handbook, provide a further education, offer 2 free online courses, provide many pertinent documents, provide pertinent information, provide for a national platform for communication among sheriffs, and offer authoritative advice. In short, a proper education. Constitution for the United States of America, Article 6, the Senator and representatives before mentioned, and the members of the several states' legislators, and all executive and judicial officers, both of the United States and of the several states, shall be bound by oath or affirmation to support the Constitution. Sheriffs are judicial officers. Sheriff's Oath. I hereby do solemnly swear that I will support and defend this Constitution for the United States of America against all enemies, foreign and domestic, so help me God. They also take an oath to a state constitution as well. Let us not forget that. Don't be deceived. The law is not complex. Thomas Jefferson said that common sense is the foundation of all authority, of the laws themselves, and of their construction. The law of the land consists of 1, the Constitution, written by we the people under the authority of God to empower, control, and restrict government servants, and 2, common law, which is written by God in the hearts of men, and 3, constitutional statutes, which are written by legislators. Any statute or code outside of the aforesaid, and there are many, is null and void, and that is why we need a constitutional law protector who knows the differences. If a sheriff must depend upon a lawyer to determine the law, it's no different than giving he your badge and the responsibility for your oath. That is not honoring your oath. Lawyers already run our government, and quite frankly, they've run it into the fucking ground, and have the people ratcheted down in unconstitutional codes, statutes, and illegal warrants. Therein is the problem in a nutshell, and the reason we need sheriffs who know the law. Lawyers rejected the counsel of God. Luke 7:30. The lawyer said, and unto Jesus, Master, thus saying, Thou reproach us also? And Jesus said, Woe unto you also, ye lawyers, for you laid men with burdens grievous to be borne, and ye yourself touch not the burdens with one of your own fingers. Woe unto you, lawyers, for ye have taken away the key of knowledge. Ye entered not in yourselves, and them that were entering in you hindered. Luke 11:45-46 and 52. In order for statutes to become law, the legislator must first be given authority by we the people, which is found under Article 1, Section 8, which is restrained by Article 1, Section 9, and the Bill of Rights. This is where the sheriff's attention should be. If Congress writes statutes outside of Article 1, Section 8, or statutes that violate Section 9 or the Bill of Rights, the following general rule of the United States Supreme Court is to be applied, and herein is the power of the county sheriff. The general rule is that an unconstitutional statute, though having the form and name of law, is in reality no law at all, but it is wholly void and ineffective for any purposes. Since its unconstitutionality dates from the time of its enactment, in legal contemplation it is as inoperative as if it had never been passed. Since an unconstitutional law is void, the general principle follows that it imposes no duties, confers no right, creates no office, bestows no power or authority over anyone, on anyone, affords no protections, and justifies no act performed under it. A void act cannot be legally consistent with a valid one. An unconstitutional law cannot operate to supersede any existing law. Indeed, insofar as a statute runs counter to the fundamental law of the land, the Constitution, it is superseded thereby. No one is bound to obey an unconstitutional law, and no courts are bound to enforce it. Bonnet versus Valerie, 116, N period, W period, 885, 136, Wisconsin, 193, 1908, Norton versus Shelby County, 118, U.S., 425, and 1886. Show us a county sheriff that does not know the law, and we will show you a lawless county. Because it is in the nature of the unrestrained government servants to seize more and more power and control over the people, and this is precisely why we need a true lawman who take pride in the knowledge of the law. The office of the sheriff is not to blindly enforce codes, rules, and statutes, but to enforce the law and constitutional statutes that prevent lawless servants from injuring the people. It's up to the sheriff to bind the government servant down for mischief. Bind the government servant down from mischief by the chains of the Constitution. Thomas Jefferson. If a nation expects to be ignorant and free, it expects what never was and what never will be. Thomas Jefferson. The county sheriff also has a duty to enforce the common law, which is written by God in the hearts of men. There are two common law principles that guide us in knowing the common law. 1. In order for there to be a crime, there must be an injured party, and the government in general cannot be the injured party. And 2. For every injury, there must be a remedy. This is the simplicity of God's law. Do not kill, do not steal, do not injure, do not trespass, etc. We all know this. What separates the sheriff from the police is the fact that police are code enforcement officers that answer to a political servant who has the power to fire. And if the political servant is lawless, so are the police. Whereas the sheriff, as law enforcement officers that answer to we the people directly at the ballot box, therefore the sheriff will be as lawful as his knowledge of the same. There are only 3 ways a sheriff can be removed from office. 1, the people can vote him or her out. 2, impeachment. And 3, indictment by the grand jury. There's also a 4th one. It's called the coroner. You can get a hold of the coroner and you can remove the sheriff through the coroner. He does have the power to arrest the sheriff. There are 4 things the sheriff needs in order to arrest a lawless judge or any lawless elected or appointed servant with impunity and fearlessness. They are 1, knowledge of the law. 2, knowledge that no agency or elected or appointed servant can remove a sheriff from office, nor can a sheriff be arrested unless she or he has violated the common law, such as stealing, killing, etc. 3, the people standing behind him. And 4, access to the grand jury to get an indictment. The sheriff should not be going to the county prosecutor for an indictment, as all too often they are gatekeepers for the lawless. Now, there's something in this literature that isn't mentioned, and the fact is that a sheriff has the ability to do what is known as a sheriff's inquiry, okay? And the sheriff can collect evidence of the lawless servants, and then he can gather all the evidence up, and he can call a grand jury, okay? And it's under the a sheriff's inquiry, which is basically where the sheriff is holding his own court, doing his job constitutionally, protecting the people who put him in power, who put him in place, to ensure that the people in the community are not ravaged by the lawless heathens, the lying, looting, pandering piece of shit lawyers that are fist fucking everybody dry. All right? It is imperative that the sheriff have the active support of the people. The best place for the sheriff to find that is in locally controlled citizen and liberty groups. Go out and talk to them often. Ask for their support to help you protect their unalienable rights, because they are the most active and will show up to support you when you need them. Now, there are a lot of sheriffs out there that are doing a great job of having community meetings, volunteer fire departments, so on and so forth, and we commend them for that. But they also need to continue to do their due diligence to ascend of the mind and to realize what really happens when, as a sheriff, you go to the fox guarding the hen house and ask them if they're stealing fucking chickens. Of course they're not going to tell you they're stealing fucking chickens, even though they got feathers all over their fucking face. It doesn't take a rocket scientist to figure out what the fuck they're doing. Sheriffs should keep their eye out for community communities of safety, COS, which are exploding across the nation. All 56 signers of the Declaration of Independence were members of the Committees of Safety. Committees of Safety are the most powerful tool the sheriff can have because they are we the people. Learn about them. To see if there are communities of safety in your county, you can go to www.powerofthecountysheriff.org and click on the COS tab to find one. If there are no committees of safety in your county, you can contact the National COS Committee Chairman, whose job it is to help start independent grassroots committees of safety, and he will contact patriots in your county and encourage them to start a COS and connect you with them. Sheriffs need to have a proper education, and that doesn't mean educated by the Federal Bureau of Investigation of Criminals, okay? The FBI is nothing more than a bunch of scallywags, and if that wasn't proven during the Donald Trump administration, I don't know what the fuck it's going to take to show that to you. And the support of the other properly educated sheriffs standing with them, and rarely, if necessary, an armed posse, which is also known as your Minutemen. We'll stay away from Minutemen. It's kind of got a bad connotation. It's also identified as your standing militia within your community, especially if they are going up against a federal or state agency or lawless government servants. You can go to www.powerofthecountysheriff.org to find such an education and unite with other sheriffs who are awakening. That's right, because your daughters, your sons, your cousins, your friends, your mothers, your fathers are being subjected to all kinds of lawlessness. We're seeing it every day in the propaganda news media of all these politicians just getting away with absolutely heinous crimes. And nothing's being done. So what can we do effectively? We can stop participating with those dickheads and cut them off financially and stay within our community, supporting our local farmers, supporting our local sheriff, kicking out the judges out of our damn courthouses because they're merely renting our courthouses for their private for-profit gains and business, utilizing the UCC for their private ad hoc corporations, okay, to unjustly enrich themselves, all while under the guise they're here to uphold and support the Constitution, all right? And we're seeing it on all levels throughout the purported judiciary, which is really operating under the executive branch, okay? And I can affirm all this shit because, well, quite frankly, I have all the DUNS numbers and SAM.gov codes and everything else that these son of bitches are doing to the American people. Most importantly, the sheriff must have grand jury access. The sheriff has been around for hundreds of years, and like the coroner, has always had direct access to the grand jury without a monitor. The only purpose of the gatekeepers is to protect the guilty, and the only reason they can't get away with having all-powerful gatekeepers is because of the sheriff and the people's ignorance of the law of the land. Just because there are lawful rules and statutes that provide for prosecutors to call the grand jury, which is necessary to empower them to do so, it doesn't negate the power and authority that the sheriff and the coroner have always had and still have the authority to call the grand jury themselves. And again, that is called a sheriff's inquiry. He goes out, he collects all the evidence, people in the community can help gather evidence, he can review the evidence, he can find what he believes to be pertinent, conclusive evidence of a crime afoot, a felony afoot, and he can conjure up the grand jury, put the information before them, and again, it's we the people that decide what the fuck is criminal and what is not. It's not for a judge to decide. The Constitution was never put in place to allow the servants to decide whether or not they're doing fucking wrong. It was always put in place to ensure that we the people could decide when they were doing wrong, and we could either have them correct the actions that they're making, or we could just get rid of them. We could abolish them. We could fire their asses. We could have them sent to Guantanamo motherfucking Bay, which, to be real cut, sweet and dry with you, I think we ought to start using. I mean, after all, the American people just invested $200 million into Guantanamo fucking Bay, and it looks like a really nice resort for fucking criminals, and I think we should start sending them there. The majority problem with prosecutors is that they think that after they get in an indictment, they have the power to add or remove charges or make deals. Only the grand jury can add or remove charges and make a deal with the accused, but they can only make a deal if they have the consent of the injured party. That is because another common law principle says for every injury there must be a remedy, and only a trial by way of jury can render a remedy without the consent of the injured party. This is common sense. This is common law, so called because it is common unto all, okay? Now, let me make a very poignant point here. So often, people are prosecuted who have actually caused harm, damage, injury, or loss to their fellow brothers and sisters in this great nation, okay? And what ends up happening is the judiciary reaps the reward through their private ad hoc private corporations, utilizing the UCC to negotiate securities and bonds, SF 24, 25, 25A, 273, 274, 275, and they're monetizing all this, all right? Now, they find the guy guilty. Obviously, the man or woman, the evidence was enough to find conviction, and that man or woman goes to prison, and again, the lawyers and the judges reap the reward of being invested in privatized prisons, and then the victim has no compensation at all. There's no compensation or justice to remedy the situation. The man or woman who aggrieved them is simply placed into a cell for which the politicians, the legislators, the congressmen, the lawyers, the judges all reap the rewards from. And there's no monetary compensation that is provided to the actual victim, okay? So what we have here is a means of extorting the American people, all while denying them their remedy, because what good is a man in jail who wronged a victim, who can't go out to work to compensate the victim for the harm and damage and loss they've been caused, right? All right, so just think about that for a second. I'm just trying to plant some seeds here. I'm no fucking expert. I'm not a man who knows it all, but it seems to make a whole lot of fucking sense to me that any profit that the judiciary or the legislator or the Congress or the state or the county would be gaining from imprisoning people should rightfully go to the victims, not to the people that have warehoused them or funded the whole operation of the purported judiciary in the executive branch, right? Just think about that for a second. Prosecutors usually throw the book at the accused, thereby inflating jail sentences, and then later offer the accused less time if they plead guilty. Okay, that's just one of the tricks of the Bar Association, because they don't typically have enough information to actually fry your ass in a court. Most lawyers are dumber than a box of motherfucking rocks. They absolutely are fucking ignorant, okay? And I'm here to tell you now, it's almost impossible to prove intent unless you yourself fucking state it, all right? And in their courts, in their legislative courts, in their military tribunal courts, you're considered an officer, you're already guilty until they continue to prove that you're guilty with an ignorant mass of fucking idiots that are going to amass a number of 12, and they're going to find you guilty because they're all taxpayers and everybody's got to pay taxes and everybody's got to have a driver's license, and they fucking all think they're U.S. fucking citizens, which is just an absolute fucking travesty, all right? So those are the facts. That's the reality of educating people within your community, because they're not U.S. citizens. A U.S. citizen is a corporation. It's a dead entity. You can act as a U.S. citizen if you like. You can carry that liability and that burden. I really don't hold any animosity towards people that feel that way, but fuck, read a book, all right? That's called extortion. The sheriff should always know when the grand jury is in session, so that if she wants to ask the people for an indictment against a judge, some other elected or appointed official, or maybe even the prosecutor, the sheriff can go to the court and talk to the grand jury directly. He need not explain himself to anyone, and if necessary, can arrest anyone who gets in his way for obstruction of justice. Once the sheriff gets an indictment, the prosecutor cannot reduce or change the charges, because that in and of itself constitutes a crime. One single object will merit the endless gratitude of society, that of restraining the judges from usurping legislation. Thomas Jefferson to Edward Livingston in 1825, M.E. 16:113. The government will certainly decide for itself on whose counsel they will settle the construction of the laws they are to execute. We are to look at the intention of the legislator and to carry it into execution, while the lawyer are nibbling at the words of the law. Thomas Jefferson to Albert Gallatin, 1808, ME 12:168. Sheriffs, whether they be a Democrat or a Republican, liberal or conservative, should not indulge in party favors. Only the law. That's your oath. This comprehensive handbook was written to fully inform the sheriffs and deputies of their powers and authorities they took an oath to perform, thereby supporting and defending the Constitution for the United States of America as well as the state that they're in. For a higher education, go to www.powerofthecountysheriff.org. Duty of the county sheriff. The sheriff is to support and defend the law of the land, aka the Constitution, and the law of nature's God, aka common law, by which the former is vested via we the people, who are vested by the latter, not legislative bodies. We are a nation governed by the common laws of God, which makes our law superior and more just than any other nation's laws. Therefore, the oath of the county sheriff is a sacred oath which, when violated, is a direct assault upon God, whose judgment will not rest forever. Thomas Jefferson professed America's covenant between God and we the people when he penned the following. When in the course of human events it becomes necessary for one people to dissolve the political bands which have connected them with another, and to assume among the powers of the earth the separate and equal station to which the law of nature and of nature's God entitle them. A decent respect to the opinion of mankind requires that they should declare the cause which impelled them to the separation. We hold these truths to be self-evident, that all men are created equal, what they are endowed by their Creator, that they are endowed by their Creator with certain unalienable rights, that among these rights are life, liberty, and the pursuit of happiness, that to secure these rights, governments are instituted among men, deriving their just power from the consent of the governed. Sheriffs and the courts. The courts belong to the sovereign people. The United States Supreme Court defines the court as an agency of the sovereign, the people, created by it, the people, directly or indirectly under its, the people's authority, consisting of one or more officers, magistrate, sheriff, coroner, and prosecutor, established and maintained for the purpose of hearing and determining issues of law and fact regarding legal rights and alleged violations thereof, and of applying the sanctions of the law, authorized to exercise its powers in the course of law at time and place previously determined by lawful authority. Isabel versus Stovall, Texas Civil Civil Appeals Court, 92 S period W period 2D, 1067 and 1070. The state and county courts are courts of record. In some cases, city courts are courts of record. For instance, New York City courts are courts of record, but all other city courts in New York State are not courts of record. To find out what courts are courts of record, look in your state constitution, which will list these courts. All other courts are called nisi prius courts, also called administrative courts. These courts are not courts of record. Unless your state constitution says differently, all cities, towns, and village courts are not courts of record. Bovier's Law defines nisi prius courts. Where courts bearing this name exist in the United States, they are instituted by statutory provisions, not constitutional. Nisi prius is a Latin term Black's Law states. Prius means first. Nisi means unless. Unless. A nisi prius procedure is a procedure to which a party first agrees unless he objects. A rule of procedure in court is that if a party fails to object to something, then it means he agrees to it. All right. So let's say, let's just put it this way. A drunk, blind, deaf girl shows up at a party with no panties on wearing a miniskirt. Just because she didn't say no, she wasn't taken advantage of? Just food for thought. I mean, any self-respecting man or woman understands what I just fucking said. Keep your hands and your feet to yourself, and it don't matter if they don't say no, if they're giving you the hinkling that they're not interested. Back the fuck off. All right? But this is how the courts operate. They rape you of your rights because, well, you know, Derek came into the court today wearing a thong, and although I didn't have any lubrication, he seemed just fine with taking it up the ass today, so we gave it to him. That's all a bunch of bullshit. An EC procedure is a procedure to which a person has failed to object. A nisi prius court is a court which will proceed unless a party objects. The agreement to proceed is obtained from the parties first. The United States Supreme Court said concerning courts of record and courts not of record, the former being those whose acts and judicial proceedings are enrolled or recorded for the perpetual memory and testimony, and which have the power to fine or imprison for contempt. Courts not of record are those of inferior dignity, which have no power to fine or imprison, and in which the proceedings are not enrolled or recorded. 3 Black's Law Commentary 24, 3 STEF, Steph Commentary 383, the Thomas Fletcher CCGA 24F 481, Ex parte Thilston 52 California 225, and Irwin versus the United States DCGA 37 F period 488 2L period R period A period 229, and Herringer versus Davis 96 Ohio ST 205 117 NE 229 223 or 231. The sheriff has a duty to provide law enforcement officers in all courts of record, often called bailiffs, which means guardians or stewards, who are a sheriff's deputy in the court, in all courts of record. Like the sheriff, deputies are to have a proper education. It is the duty of the sheriff to make sure that his deputies have a proper education. And I'm going to tell you right now, proper education don't come from lying, looting, pandering, piece of shit lawyers, esquires, these people who went to law school, who are single-handedly destroying the very fabric and foundation of this great nation. The bailiff, also known as a tipstaff, is not in the courtroom as a private bodyguard for the judge, although they are now contracted with these private for-profit ad hoc corporations, okay? But the true nature of the bailiff is he was never supposed to be subservient to the judge, ever, at all. He's not hired protection. He is there to protect the people and the judge, who is also one of the people. He is there to keep the peace by making sure the law of the land is being adhered to and that unalienable rights are not being violated. If the sheriff perceives that the judge or any other elected or appointed official for that matter is breaking the law, the best way to proceed is to get an indictment before making an arrest. Don't trust the gatekeepers, aka the lying, looting, pandering piece of shit lawyers, because he is likely to help the judge. Judges and prosecutors are both elected, both political, both bar members, both lawyers, and have a close working relationship, and therefore are likely to share a camaraderie. Go see the grand jury directly and secure an indictment. Court duties. Sheriffs are responsible for maintaining the safety and security of the court. A bailiff is required, and why are they required? For the safety and security of the court? Because the courts belong to we the fucking people. A bailiff is required to attend all court sessions, to take charge of juries whenever they are outside of the courtroom, to serve court papers, to extradite prisoners, and to perform other court-related functions. Sheriff and warrants. Amendment 4. The right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrant shall be issued but upon probable cause supported by oath or affirmation, and particularly describing the place to be searched and the persons or things to be seized. According to Black's Law Dictionary, the word oath, in its broadest sense, includes all forms of attestation by which a party signifies that he/she is bound in conscience by a solemn and formal declaration or asseveration that an affidavit is true. No warrant, including a federal warrant, is to be served without going through the sheriff's office. Any warrant without a sworn affidavit and a judge's wedding signature, not a stamp, is not an executable warrant. It is the sheriff's duty to make sure that all warrants, federal or state, served within their county passes constitutional scrutiny. IRS warrants rarely pass constitutional scrutiny. For example, the IRS has a form 4490 called Proof of Claim for Internal Revenue Taxes, which is an affidavit form that must be filled out and sworn to, without which the warrant with the wet ink signature is not executable. Sheriffs and the county jail. Sheriff's office maintain and operate county jails or other detention centers, community corrections facilities such as work release and halfway houses. Sheriffs are responsible for supervising inmates, protecting their rights, and providing food, clothing, exercise, recreation, and medical services. Before the sheriff is to accept any prisoner, he is to make sure that the due process has been exercised. If a court sends a prisoner sentenced to be incarcerated and there was no indictment and petite jury, trial by 12 jurists, before the sentencing, the prisoner is now a victim who was not given due process. The sheriff cannot accept that prisoner. Unfortunately, because of the ignorance of many sheriffs and county jailers, are filled with such prisoners. Black's law defines an infamous crime as a crime punishable by imprisonment. Amendment 5. No person shall be held to answer for a capital or otherwise infamous crime unless on presentment or on indictment of a grand jury. Amendment 6. In all criminal prosecution, the accused shall enjoy the right to a speedy and public trial by an impartial jury. The sheriff cannot accept any prisoners that were tried in courts not of record because they are nisi prius courts and do not have the power to fine or incarcerate. Courts not of record are those of inferior dignity, which have no power to fine or imprison, and in which the proceedings are not enrolled or recorded. 3 Blackstone's Commentary 24, and I'm not going to go through all that again. A lot of numbers. Sheriff is the chief law enforcement officer of the county, and the reason he's the chief law enforcement officer is because we, the people, put him there. The sheriff is the chief executive and administrative officer of the county, being chosen by a popular election. His principal duties are in aid of the criminal courts and civil courts of record, such as serving process, summoning juries, executing judgments, holding judicial sales, and the like. He is also the chief conservator of the peace within his territorial jurisdiction. Hartson versus Langstrom, Texas Civil Appellate Court 292 S period W period 648 650. When used in statutes, the term may include a deputy sheriff. Lanier versus Town of Greenville 174 N period C period 311 93 S period E period 850 853. Justice Scalia, writing for the majority in a 1997 decision, said that the states are not subject to the federal direction, and that the U.S. Congress only had discrete and enumerated powers, and that the federal impotency was rendered express by the 10th Amendment. He further conferred that the sheriff is the chief law enforcement officer of the county, and also proclaimed that the state retained an inviolable sovereignty. Scalia went even further in his landmark decision, one in which 2 small-town sheriffs headed the feds off at the pass and sent them on their way. Scalia, in his infinite obligation to the Constitution, took this entire ruling to the 10th power when he said, "The Constitution protects us from our own best intentions, so that we may resist the temptation to concentrate power in one location as in expedient solution to the crisis of the day. Obviously, the sheriff is the people's last line of defense against a government gone rogue. Law enforcement. A sheriff always has the power to make arrests within his or her own county. Some states extend this authority to adjacent counties or to the entire state. Many sheriff's offices also perform routine patrol functions such as traffic control, accident investigation, and transportation of prisoners. Large departments perform criminal investigations, and some, usually large sheriff's office, command an air patrol, a mounted patrol, or a marine patrol. Sheriffs still enlist the aid of the citizens. The National Neighborhood Watch program, sponsored by the National Sheriff's Association, also citizens and law enforcement officials to cooperate in keeping communities safe. This is why the new mission of the Indiana Sheriff's Association and their slogan is building communities of trust in all 92 Indiana counties. As the sheriff's law enforcement duties become more extensive and complex, new career opportunities exist for the people with specialized skills: underwater diving, piloting, boating, skiing, radar technology, communications, computer technology, accounting, emergency medicine, and foreign languages, especially Spanish, French, and Vietnamese. Just courts of law rest upon 6 foundational truths. 1. Truths are self-evident. 2. All men are created equal. 3. We are endowed, gifted by the Creator. 4. We have unalienable rights. 5. To secure these rights, we have a right to institute governments, constitutions. And 6. Governments that derive their just power from the consent of the people, wherein we ordained and established the following. We, the people of the United States, in order to form a more perfect union, establish justice, ensure domestic tranquility, provide for the common defense, promote the general welfare, and secure the blessings of liberty to ourselves and our posterity, do ordain and establish this Constitution for the United States of America, preamble to the Constitution for the United States of America. Therefore, by the powers vested in we the people, by God, we the people did ordain and establish vested powers to our government servants, who are bound by the chains of the Constitution, thus their oaths to the following 6 ends alone. 1. Form a more perfect union. 2. Establish justice. 3. Ensure domestic tranquility. 4. Provide for the common defense. 5. Promote the general welfare. 6. Secure the blessings of liberty to ourselves and our posterities. No legislation is to pass that does not, in the end, serve one or more of the aforesaid 6 ends, and legislation to the contrary is null and void, and the sheriff is bound to treat it as such under the following general rule. General rule. The general rule is that an unconstitutional statute, though having the form and name of law, is in reality no law, but is wholly void and ineffective for any purpose. Since its unconstitutionality dates from the time of its enactment, in legal contemplation, it is as inoperative as if it had never been passed. Since an unconstitutional law is void, the general principles follow that it imposes no duties, confers no right, creates no office, bestows no power or authority on anyone, affords no protection, and justifies no acts performed under it. A void act cannot be legally consistent with a valid one. An unconstitutional law cannot operate to supersede any existing law. Indeed, insofar as a statute runs counter to the fundamental law of the land, the Constitution, it is superseded thereby. No one is bound to obey an unconstitutional law, and no courts are bound to enforce it. Bonnet versus Valerie, 116 NW 885 136, Wisconsin 193. This case was in 1908. And Norton versus Shelby County, 118 U.S. 425 1886. Any sheriff unable to understand and enforce the general rule violates his oath of office and wars against God and we the people, as well as the Constitution. For the sheriff to correct this error, they are there are only two choices. 1, study and show thyself approved by your oath, or 2, resign the office of sheriff. It is also the duty of every sheriff to retain their duties in the law of the land. This is the very purpose of this book, to train up our sheriffs and deputies in the way they should conduct themselves and not depart from it. It has become agonizingly obvious through communicating with many sheriffs and their deputies across the nation that the majority of them are not properly educated and do not understand their oath and authority. Law of the land. Law. That which is laid down, ordained, or established. Coing versus Flynn, 258 NY 292 179 NE 705. U.S. Constitution, Article 6, the Constitution and the laws of the United States, which shall be made in pursuance thereof, and all treaties made or which shall be made under the authority of the United States shall be the supreme law of the land, and the judges in every state shall be bound thereby. Anything in the Constitution or laws of any state to the contrary notwithstanding. In conclusion, law is all about the securing of the unalienable rights. We do not need a PhD to know and understand the law. We need not yield our understanding to statutory lawyers, aka bar attorneys, aka lying, looting, pandering pieces of fucking sniveling shit. The Bible tells us that lawyers reject the counsel of God. They lay upon men grievous burdens and take away the key of knowledge. The Bible tells us that God has written his laws in the heart of all men. We, the people, can know right from wrong. We do not need legislators and lawyers to tell us. That is precisely why we, the people, never gave our servant legislators authority to write statutes that govern our behavior, nor did we give judges and prosecutors the authority to indict or judge we, the people. That authority we reserve to ourselves via unattained juries, with the power of nullification. Common law is built upon logic and reason through maxims and principles. Maxims are self-evident truths, such as all men are created equal, that they are endowed by their Creator with certain unalienable rights, that among these are life, liberty, and the pursuit of happiness. For every injury there must be a remedy, and for there to be a crime there must be an injured party. Principles are a state of mind that always need to be considered, such as honor, justice, and mercy. Likewise, we need not yield our trust in understanding the law to bar attorneys. Thomas Jefferson told us, who was a former bar attorney, but, well, he wasn't a bar attorney, he was a lawyer, he was an esquire, all right? Laws are made for men of ordinary understanding and should, therefore, be construed by the ordinary rules of common sense. Their meaning is not to be sought for in metaphysical subtleties, which may make anything mean everything or nothing at pleasure. The purpose of a written constitution is entirely defeated if, in interpreting it as a legal document, its provisions are manipulated and worked around so that the document means whatever the manipulator wishes. Jefferson recognized this danger and spoke out constantly for careful adherence to the Constitution as written, with changes to be made by amendments, not by torted and twisted interpretations of the text. A rule of thumb concerning the constitutionality of any legislation or interpretation of the Constitution is to ask if the conclusion violates any of our unalienable rights, and if it does, it's null and void. The laws of nature and nature's God. The judicial power shall extend to all cases in law and equity. U.S. Constitution, Article 3, Section 2. The laws of nature and nature's God is called natural law or common law, so called because the law is common unto all men, and no one can escape its judgment, which will be applied either in true courts of justice or on the last day. According to Black's Law, 4th edition, the key phrase in law means in the intendment or contemplation of the law, existing in law or by force of law. It is in fact actual, real, as distinguished from implied or inferred. Philosophically, it seems more correct to say that the word land means in law, as in the vernacular, the soil. The term land may be used interchangeably with property. It may include anything that may be classed as real estate or real property. Reynolds versus City of Caldwell, 55 Idaho, 342, page 2D, 292, 297. Law of the land lifted from Magna Carta means due process equals process due and owing to all concerned, sometimes called the paths of the law. Therein, the constitutional phrase, law of the land, property for it is God who created all things for his pleasure, and said, the world is mine. All men are mine, all souls are mine, and all gold and silver is mine. We the people and all of creation are God's property. God is the lawgiver and the judge, who gave us the law of liberty via unalienable rights, thereby making us free. And we the people, through the jury, grand and petite, sit as the tribunal on the king's bench, to exercise the law of the land, and no man by way of legislation or decree can take we the people's liberty without consequences. Black's Law states that the phrase at law is used to point out that a thing is to be done according to the course of the common law. It is distinguished from a proceeding in equity. Law is that which is laid down, or ordained, or established. Thomas Jefferson was a student of Lord Bolingbroke. He first began studying Bolingbroke's writing at the age of 14, and he read them again at the age of 23. As he was preparing for a career as a lawyer, Jefferson literally commonplace book contains more quotations from Bolingbroke than from any other author, and all historians had given Bolingbroke the credit for Jefferson's famous phrases regarding the law of nature and of nature's God. In a renowned letter to Alexander Pope, Lord Bolingbroke wrote the following words, which were to become the basis for Jefferson's opening paragraph of the Declaration of Independence. You will find that it is the modest, not the presumptuous inquirer who makes a real and safe progress in the discovery of divine truth. One follows nature and nature's God. That is, he follows God in his works and in his word. Here we find a definition from the very individuals that all scholars recognize as the source of Jefferson's phrase. According to Lord Bolingbroke, the law of nature and nature's God is the law which is founded in God's word. This was the definition which was intended by Jefferson, and this was the manner in which his words were understood by our forefathers. The law of nature's God upon which our nation was founded is not less than the Bible itself. The laws of nature are most perfect and immutable, but the condition of human law is an unending succession, and there is nothing in it which can continue perpetually. Human laws are born, live, and die. 7 Coke 25. As one might expect, the Bible is fairly clear on the subject of the supremacy of God and his law. It indicates that there is no God except the Lord God. God is the God of creation, and he is the creator of all things visible and invisible. God impressed his laws upon creation, and he governs its operation accordingly. God gave his laws so the people would seek after God and know that God requires what God requires of every person. Of course, the law of God are right, perfect, and eternal. They apply over the entire globe and are written in God's creation because God is the creator of all the earth. The rules also apply to all people and are written within each man, woman, and child because God is the creator of all people. God also reiterated the basic elements of his rules of right and wrong in the Bible. The implication of this situation are straightforward. Since God created all things, he also has the right to rule them according to his laws. He rules the nations according to his laws. His laws rule the nations irrespective of whether a given nation believes in God or recognizes his laws. This does not mean that the nations are perfect, nor does it mean that the people who do not worship God cannot rule, nor does it mean that God will judge lawbreakers according to our timetables of justice. It does mean, however, that God will not let a corrupt government rule forever. God judges justly on the earth and punishes lawless leaders and nations. Nations which forget God may completely perish. Nations which honor God and try to follow his laws, however, can expect to receive his care and protection. When we come back, because my computer's about to die, we will tackle legislative law is vested law, okay? And we'll see you real soon.